Why does someone, a broadcaster, a digital publisher, need an IP attorney?
Intellectual property is, what it refers to is the creations of the mind. So they're intangible assets that you create, again, from the mind, right? So they include inventions, literary and artistic works, designs, symbols, so again, logos, names and images that we use in commerce to, typically monetize in some way. You need somebody to help you navigate through that framework. You want someone who is knowledgeable, who can weigh these factors to let you know whether it's worth the risk.
Welcome to As a Result. I'm your host, Ashley Smith, founder and CEO of Dimensions Media, and we're bringing you conversations with media leaders covering the latest news and trends in broadcast radio, television, streaming, podcasting, and digital publishing. We have a very enlightening show ahead of us, featuring a very special guest. Today, we are joined by Miss Dayna Cooper, Esquire. Dayna is the principal attorney at Cooper Legal LLC, where she practices intellectual property law with a specific focus on marketing and advertising. We will discuss digital marketing and advertising compliance for publishers. This covers a variety of topics, including licensing, fines, content ownership, trademarks, copyright, data, accessibility, and a whole lot more. I know anytime we speak about compliance, things can become complex very quickly. So before we join the conversation, I want to make the connection of how intellectual property law fits into your broadcasting operation. The evolution of broadcast radio and television now includes digital platforms that are regulated by a governing body, very similar to your interactions with the Federal Communications Commission. These new platforms require compliance. You want to remain compliant to prevent hefty fines and to maintain use of your platforms. The role of an IP attorney is to function as an expert in regulations and help digital publishers maintain compliance, protect an organization's assets, and help you, as a publisher, protect the privacy rights of your online users. So we're talking about everything from your station branding and logo to the content you create and distribute across your platforms, AI, maintaining accessible websites, and how you collect your user data. Now that we have the background, let's join the conversation. So without further ado, I would love to introduce Dayna Cooper to the show so she can make all of this make sense. Dayna, welcome to the show.
Thank you, Ashley, for having me.
Wonderful. So as we always begin, we want to know how you got to where you are, how it all started. So give us some background on your career.
Sure. So right out of law school, I had a 9-to-5. I wasn't practicing law. I did IT project management for a little bit of maybe over a year or just under a year, where I got to learn develop some in-depth knowledge and great insight on technology, the life cycle of technology and projects, tech law, tech licensing, and government contracting as it relates to technology, all of which I employ in my practice today. Although, people who are probably viewing this podcast may not think that is relevant, but technology licensing and protection of technology has all of the same components that the broadcasters would need, believe it or not, in protecting their content. But after IT project management, I ended up at the Copyright Office for about 6 years, I believe it was, where I ultimately ended up in the Acquisitions Division, acquiring works for the Library of Congress and advising publishers on their obligations and rights with respect to the copyright laws. And like I said, acquiring works for the Library of Congress. Then in 2018, I hung my shingle and started my private practice full-time.
Oh, that is wonderful. Congratulations on all of your success. And I'm so happy that we found you. She has been very helpful in making all of the complexities make sense. So with that, a very experienced background, to give us some ideas about your education. I know that you're also a FAMU alumni.
I am. So, as you said, I am a proud alumnus of the Florida Agricultural and Mechanical University. I have a BA in political science and public administration. After graduating from law school, I took a year off and just worked. I ended up at FAMU College of Law, so I am a double rattler. I did a year there, and then I transferred to University of Baltimore. After law school, I decided that I was never stepping foot in the classroom again. So that pretty much sums up my educational background, probably for the life of me.
Well, we could say that, but from the conversation that we've had, because of intellectual property law, because of the digital, the way that it evolves, you're always learning. So pretty much, you're just in your own office, but you're still in the education realm.
That's true.
So thank you for telling us about that. But what I really want to do is that you make the connection for our broadcasters and the audiences of why does someone, a broadcaster, a digital publisher, need an IP attorney?
Sure. So,
you know what? Before I let you do that, tell the people, what is intellectual property?
Okay, so intellectual property is, what it refers to is the creations of the mind. So they're intangible assets that you create, again, from the mind, right? So they include inventions, literary and artistic works, designs, symbols, so again, logos, names and images that we use in commerce to, typically monetize in some way.
Okay.
Go ahead.
Go ahead. No, now tell us, why would a broadcaster or digital publisher need your services?
Sure. So, my firm offers a host of services, but as it relates to the conversation today, so they do need IP protection, because a lot of the content, right, is protected by copyright laws. They may have trademarks, so logos and slogans that they may want to protect. There may be some, I can't really think of anything right now as it will relate to trade secrets, but that's a type of intellectual property. I can't think off the top of my mind how that might relate to radio broadcasters, unless there was like some internal process that they were creating that allowed them to have some competitive advantage over their other competitors. But copyright, like I said, copyrights definitely, trademarks. And I also do media and internet, cyber law, data privacy. All of those things are directly related to advertising and broadcasters because, like I said, they want to protect their content. Like you said in the beginning of the broadcast, is that they want to ensure that they are handling data privacy matters within the regulations and the laws. What else? And you want to ensure that you are in compliance with FTC regulations and other state laws as it relates to marketing and advertising restrictions that you may have, or disclosures that may be required for the public.
Wonderful. So you took me right into the next question of the FTC and the governing bodies that regulate marketing and advertising, as well as what we're doing with the digital platforms, the apps, the streaming. Our members are very familiar because with their terrestrial signal, they work with the Federal Communications Commission. So they are very understanding of what that compliance is like. Mm-hmm. Tell us about the governing bodies. And you've mentioned that there are multiple, but tell us about a few of the governing bodies that you are learning about and educating yourself in order to help members and your clients when it comes to compliance and regulations.
Okay, sure. So I would definitely say at the top of that list, we're looking at FTC, so the Federal Trade Commission. Underneath the Federal Trade Commission, they're handling everything as far as, so trademark law falls under that. Then FTC has an FTC Act, and they also have administrative guidelines to follow as far as marketing and advertising are related. Then you always have the courts and case law that govern the transactions, right? So sometimes people may refer to it, may recognize it as case precedent, something of that, along those lines. And then too, you also have industry guidelines and standards. So there are, advertising organizations that are grouped together that set their own standards for that particular industry. The food industry has one, and so does advertising. So you want to ensure that you want a lawyer to help you ensure that you are compliant with all of those, that you are aware of what those laws and, like you said, those governing parties, so that you can at least make inquiries to those, to the, for instance, regulatory agencies, to get some information or insight into whether what you're doing is proper, so that you can avoid some of those hefty fines.
Yes, and I'm going to take us into some of those hefty fines. We're going to talk about some examples on the large scale and on the small scale. And then even when we were preparing for this, you were telling me that, small broadcasters and smaller digital publishers, they are more vulnerable to these fines. And so what I'm going to take you into is what everyone is talking about right now. And that's why digital has its leg up when it comes to data and data compliance. I read the headline, that Meta was fined $276 million over a Facebook data leak involving more than 533 million users. And so this leak took place in April of 2021. And the information that it included, and I want to make sure that we stop here and we really focus on this, is called personally identifiable information. And I'm going to let you talk a little bit more about what that is and what happened here, and ultimately how did they come to this fine?
Sure. So, personally identifiable information, also referred to as PII. Essentially, what it is it's sensitive information that identifies a particular individual. So the FTC has laws about. Let me back up a little bit. So there are federal and state laws as well as local regulations that govern how an entity can collect data, how they can use that data, whether or not they can disclose it, and if they do disclose it, how they disclose it, the retention of that data, maintaining that data, and giving individuals some authority over how their data is used. Well, Facebook failed. If you think, what was it, $200 million is a lot? The year before, they were in trouble, and the FTC actually is the largest fine to date that I know of for $5 billion.
Wow.
For $5 billion. So you think about some of the so you're talking about smaller publishers being vulnerable. I think the conversation that we had was about content ownership. Mm-hmm. But if we talk about fines, you think about, so small publishers are vulnerable, because if you think about, Facebook should know better, right? They have the legal, support there to advise them. And to provide some type of support for them so that they can avoid some of these things. So think about somebody's budget who doesn't look like Facebook's budget. So tell me that's not vulnerable. So
very vulnerable. And
right. So you have to make sure that, and I think you said we would talk about data privacy later, but that's just, talking back to the point about why you need a lawyer. You need somebody to help you navigate all of these different state laws. So California has one, Colorado has one, Utah has one. And then again, you have FTC guidance. You need somebody to help you navigate through that framework. Like I said, Facebook has a huge budget, right? I'm sure. And they failed to ensure that, that they were following the appropriate guidelines. So I think that's a prime example of why you need counsel.
And so we're going to get to that a little later, but for anyone who wants to know examples of what this personally identifiable information is your phone numbers, where you live, your birth date, any of those things like that, because on the back end, if you have more advanced marketing capabilities, then you're doing addressability and you're doing targeted ads. And so we will talk about that, but for everyone who is a broadcaster for a number of years, you've been collecting information from your audiences, and maybe in the form of a newsletter. So for anyone who might think, oh, I'm not collecting data, I will tell you this. When I'm speaking with Dayna, she always alerts me that, hey, you might want to think about that. That's also a form of data. So we'll make sure that we'll go down into the weeds of that. So that was on the large scale. We don't want to scare you, but we do want to share with you even what the larger organizations are experiencing. So now give me an example of some small scale, and I'll even start us off, and I don't even really consider it small, but the stock images that you're using. So if you have a digital publishing department and you guys are creating promotions for your concerts, if you're creating ads for some of your sponsors, anything where you're taking content that maybe if it's a graphic, a picture, or illustration, if it's audio, and you're getting that from somewhere that someone else who owns that, and you don't give the proper credit, or you don't know the type of licensing that you have, and you use it incorrectly, you could be fined. So that is a small scale version of what I've seen, and that can even balloon up into even larger hefty fines based on how many times there's an infraction. So you tell me, Dayna, as the attorney, give us some small scale examples of some of those fines that you can receive.
Sure. And before I do that, so I'm sitting here smiling and nodding my head like a proud mama because because I hear that you have been listening.
Hey.
And you are comprehending. So yes. I am so proud. I'm definitely so proud of my baby. But no, you are absolutely correct. So like you said, for all of the content that you are not generating, that these organizations are not generating on their own, belong to someone else. So they need to ensure that they have the proper clearances, releases in place in order to avoid infringing upon somebody's rights. So we talked a little bit earlier about copyright. So you were asking about images. Typically, those images are protected by copyright law. If you do not have a license, and all a license is a contract, it is permission to use someone else's work. So if you don't have a license, the general rule is if you do not have a license, you should not use the work. There are some exceptions, but we should really just stick to the general rule. And if you really need it, so if you are like an educational institution or, a news outlet, and you need the work and you don't have a license, there are some exceptions that are available to you. But you need a lawyer to help guide you through it, because there's not a bright line about what constitutes. So what it's called is fair use. So what constitutes fair use? But I know we're going to talk about that later.
You can go into it.
Okay. So, but I want to answer your first question. Mm-hmm. So your first question was about
small scale examples of fines.
Right. So Getty sends out a lot of cease and desist because people are still, they allege that people are stealing or not licensing the images, the content, right? So you may see something for $700, $900, $1,000, but I've had quite a few people who come into my office from some stock image, with some cease and desist from a stock image company, and they are alleging upwards $50,000, $40,000, $50,000. So that's a lot of money when you could have just paid the $70 to license the work. Nobody ever thinks that they're going to get caught, but with all this technology that we have, I personally wouldn't risk it.
Yes, and what I want to touch on for broadcasters is that this is a lot of complex information, as she just says, it's connecting with you. You have to think about it. I've been working in this industry for 10 years now, and I'm working in it every single day. You are not, as a broadcaster, you're not going to be into the weeds of this. So what we recommend is that you have yourself a digital director, a digital strategist, or someone who sits in that seat, and this is their world. This is their job. They may not know the exact laws or the ramifications, but they know that, hey, I need to think twice before I do that. Mm-hmm. Where did we get this picture from? Where did this audio come from? And we'll talk about it as well, because there are different types of licensing. So she said fair use. So fair use, if just like you guys are newsworthy. If you're putting out newsworthy information where you're educating the community, that is one lane that you can take. However, you're also creating advertisements for your sponsors. So if you have a license for a particular image and you use that image for an ad that is for a service or monetization, that's a totally different type of license. And so that's what you want to make sure that you have a leader in your digital department. They know that. But then they are also transferring and training that to the team, because I have seen multiple lawsuits come in, and that's because the team was not aware of those licensings. Mm-hmm. And so we had to go back through websites and just scrub them of all of the graphics just so we wouldn't incur any more type of legal ramifications. So that is the gist of all of that. Dayna, you have something to say?
Yeah, sure. So, and another thing to note is that, so you were talking about a director, someone who sits in that seat, but documented policies and guidelines to help. That director may not be there forever, right? And that person can't do everything. So if you have documented guidelines or policies for your employees when they're doing, when they're launching a new campaign, that will help tremendously instead of, you have a new person come in and they're just shooting in the dark trying to figure it out. That's a recipe for disaster.
Oh, it definitely is. And it definitely is, especially when we're talking about events, because our stations put on a lot of events. And so unless you have a cleared image of whoever that entertainment is going to be and they provided it to you themselves, this is not the time for you to go to Google and just download an image that you see in the Google Images page. So she brings up a very good point that we have been working on and I've worked on with organizations. So you are preventative. Dayna is huge about being preventative. So
oh, yeah.
We're talking about subscription costs, and I've talked to many broadcasters about it. And when you're looking at, do we actually have the money, the budget for that? Is that going to bring in the ROI that we're looking for that subscription? It will in the long run. It will in the long run if you have a new social media person who is not aware of the policies that we're speaking about. Something exciting happens in the news and they want to make sure that they get that story out immediately. And they just take that from somebody else's, either from the website or somebody else not giving credibility on social media. This happens all the time on social media where we just steal images without giving credibility. So we're not going to get stuck on this here. I'm going to take us a little bit further because what I really want to do, I'm huge on application. I want to go through the different scenarios that you as a broadcaster that you have with the different platforms that you have. So we can talk about those areas that where IP law is applicable. And then also just to give you some examples, and Dayna has some legal studies that she's going to share with you as well. So what we're going to do now is we're just going to start with our station owned and operated digital websites. Most of the stations have their own websites where they distribute content, editorial, video. This is where your streaming player for the most part lives if you don't have an app. But even before that, when we just talk about the basics on your website, you have your logos and your taglines. And that's where copyright and trademark comes through. And I have seen many web stories and news stories lately. Just simply, if you look at a logo where someone may take something that looks very similar and they use it for another use, but the whole visibility of it is very similar to yours. So give us some examples of what we mean by the copyright and trademark when it comes to branding in your logo for your station.
Sure. So when we talk about branding, generally we're not talking about copyright. We're generally talking about trademark. However, there are some exceptions. Some logos are copyrightable, but we don't have time to distinguish which ones today. But you do want to distinguish your brand from someone else's, right? So trademarks are essential. What trademarks are is identifiers for the public. So the public can be aware of where that particular service or product is originating from, right? If you build up this great reputation, this great brand, so that's what you want to think of when you think of trademarks, is a brand. If you build up this great reputation and brand, you don't want someone else to create another product or service and ride off of your brand, right? So that is what trademark protection protects, okay? As far as so we talked about logos. You can also trademark taglines. So we all know Nike. So the swoosh is their trademark. That's the logo. So when we see that swoosh, we know the reputation that comes behind those sneakers, right? So I'm just trying to pull it all in for us, right? Then the tagline that they have that's protected is "Just do it," right? So that can be protected. So when we see that, we associate it with a source, right? Nike. Some others are, I think Allstate has the logo with the hands. Yeah, that is because the brand is "You're in good hands with Allstate," right? So that's just a few examples of trademark and logos. I knew you did ask me about this in advance. I couldn't think of any as it relates to news and broadcast. I did Google like CNN and Fox, and they do have some taglines, but I didn't see them register trademarks. Although trademarks don't have to be registered, I wanted to use something that was registered. But that's two examples. Again, I'm sorry they're not related to this industry, but I think that's enough information to give people an idea of, station branding, how to protect their branding. As it relates to other protective, we touched on protective mechanisms. We touched on copyright a little bit. So as a station, radio broadcaster, or someone who's building content for a newspaper, you want to think about that content. So do you have photographers taking photos? Depending on if you own it or the photographer owns it. At any rate, you pay for it. You probably don't want somebody else that's not the photographer to just snatch it off of your website and then put it on theirs and then put the same story. Because they can talk about the same story because facts are not protectable. So what stops them from taking the photo that you paid for to use on their website? So that's an example of copyright content that you want to protect. What else? Typically with copyright, you want to think about the prevention of copying and think about piracy. So you don't want someone to copy the work and take it as their own. But like I said, there are some limitations, especially in this field, because news isn't necessarily protectable. But you may have some editorial works, some other literary works that may have been included in your publication that the publication owns, that they don't want someone else to be able to copy. So you want to make sure that you have the appropriate mechanisms or protections in place so that you can enforce those later.
Yes, and I'm so happy that you took us there. Content is huge. That's all broadcasters do every day as far as the information they're distributing over the air terrestrial signal and then what they're doing online. And we are in the age of original content. Every time you turn around, a broadcaster, if you're a Hulu or a Netflix, your whole ideal is to create original content because it is exclusive to your platform. If someone copies that content, it's no longer exclusive to your platform. You're also not meeting the goals and objectives of why you created it. So some examples of that are some of your web series. If you have anything online, if you're creating YouTube videos, very similar to like what we're doing right here, we have this podcast. If someone were to take and download this video without permission and put it on their YouTube channel, they have now that is now copyright infringement. Okay, so and am I correct in saying that, Dayna?
That's correct. Mm-hmm.
Okay, so you also want to think about the news stories that your bloggers are putting out. That's why when you're reading news stories, normally you'll read the story, but then maybe your news director has placed this story first appeared here. It's giving credibility to the source, and that's what you always want to do. Give source to whoever, as she was saying, is the owner of that content. And we're going to talk about content a lot, from the videos that you're using, the audio that you're using, especially to create that original content. But before, you know what? We can go into that. So as you're creating your content, you're using this stock footage, as she mentioned, Getty. That's one of your most prominent stock. What? Say it again for me.
That we paid for.
Yes, that we paid for. You've got Adobe stock. You've got Dreamtimes. There are a lot of different stock subscription companies, and there's a lot of them that are free. But make sure that you're reading the fine lines and learning how to, when they say this is okay for fair use. However, when you post this is the description, or this is the credit that you need to give. Make sure that you're reading the fine lines. But with that, you're creating these videos. You're using this stock footage, whether it's a transition, a motion graphic, maybe it's some B-roll that's in that video. All of the same issues are true there. So although you own that original content, you still had to pay for some of the content that was inserted there. So you're going to make sure that you copyright your own footage inside of your YouTube description, which Dayna has helped us with. And then you're also going to make sure that you give credit to the people who own some of the features that are inside of your content. And so what we're going to do now, we're going to move on to the one where I see it's the most egregious. It's social media. And all I'm going to do is say hashtag ad, and I'm going to let Dayna go to work. So tell us what hashtag ad is.
Okay. I'm sorry. I know you said we were going to move on, but I just have to say something about fair use and those licenses. So a lot of people think, oh, well, I pay, even if you pay for it, there are different tiers and there are different levels to those licenses. So if you pay for just a license for personal use, you cannot then put it on, even though you paid for the license, that license has some restrictions. So you cannot then go on and use it for commercial purposes. So we're not talking about fines here, but you're talking about potential copyright infringement or contract law. Because that license that you entered into is a contract. So you want to make sure, you definitely want to make sure that you read through whatever that license is, because it doesn't mean you can just use it for anything.
And Dayna, before you go on, I want to stop you there, because one thing I want to let people know is you can get these fines, but depending on the platform, wherever that infraction happened, you could also lose your channel. So if you happen to put out a video and you don't have clearance on the audio, the background music, or a particular image that's there, if the technology catches that, and if you do that 1 or 2 or 3 times, and I know YouTube is really good for this, they will say, hey, there's a copyright law infringement on this particular video, but it's okay. This particular owner allows this. So that happens. And then what they might also do is to say, you can use it, but you cannot monetize this particular video. And so we know that we have all these distribution platforms because our whole ultimate goal is to monetize. So it only it hinders you from your overall objective if there is copyright included. But then what they might also say, and I've seen it happen on social media a lot of the times, too many infractions, and they say, you know what, your channel, you're not going to be able to use it for a month or 2, or you might lose it just in general. So Dayna, keep going for me.
So some of these licenses too, you have to be careful, because so on a lot of these platforms, a photographer sold the photo to Getty or Adobe or whatever, and they may get a royalty, right? They may get a flat fee and a royalty. I don't know in depth what those contracts look like. But you also have to be careful with how you use that photo. I'm going to give you an example. I can't remember the year, but it was a couple years back. There was a case in New York where the New York Department of Health or I don't remember what it is, but a health services agency in New York took a photo from one of these stock images of a model and used it in an HIV ad. And the ad said, I'm HIV positive and something else, right? She sued them and everybody in that chain of who touched that photo, because there are restrictions on how you can use somebody's image and the message that you're conveying in that work. So you really have to be careful with how you're using stock footage. It's not a free for all at all.
And so, and they're going to be different, the terms that I guess it's the names for the licensing types. But what I'm very familiar with is, you said the fair use, you've got Creative Commons. They'll tell you, hey, this is strictly for editorial usage, and they'll give you your guidelines. They'll tell you, okay, this is the thing. There are different fees for the usage. So editorial usage tends to be less expensive of an investment rather than commercial usage, because they know that you're going to monetize. And so even when you pick a photo that says for commercial usage, make sure that you're reading the disclaimer about how you can use it. And then most of the times they have a chart by chart comparison, so you can see the difference, and that also helps you to determine what type of subscription you will need, so you understand your overall investment, because you guys are broadcasters, so you need the editorial, but then because you're also talking about celebrities in a lot of your stories, you want to make sure that you have access to the portfolio of some of those celebrity photos, and those tend to have different rates on them as well.
And just a point of clarification. So fair use isn't a license per se, right? I mean, it is permission to use for free. But there's no contract there. So I wouldn't call it a license. But fair use is just an exception to the rule, right? That says that for you can use this without permission for limited purposes. So we all know that back in the old days where we used to get photocopied maybe like a chapter from a book. So that is fair use, right? Because now if we copy 10 chapters of a 15-page book, that would be copyright infringement, clear copyright infringement, and no exception would apply. Because one of the, so let me back up a little bit. So let's talk about what fair use really is. So, and what the factors are that are weighed to determine whether or not a work fits in this exception, okay? So typically you won't know what the outcome is until someone has sued you and the court renders a decision. But you want someone who is knowledgeable, who can weigh these factors to let you know whether it's worth the risk, okay? So the first fact, and the factors vary across jurisdictions, but I would say there's primarily 4 or 5 that are shared across jurisdictions, and they include, so for instance, what is the purpose and character of the use? So again, is it commercial in nature, or is it nonprofit use? Educational purposes, the example that I gave earlier, right? What is the nature of the work, right? So is the work facts, or is it a creative work? Right? So I just gave the example earlier of news. Those are facts. But a photo is a creative work. So depending, again, on the work that is copied or that someone is alleged was infringed, we're going to weigh those two things. The third thing I would say is the amount or a substantial amount of the work was taken. Whether the amount that was taken or whether the amount that was taken was a substantial amount of the work. So oftentimes we hear people say, well, it only took a few seconds for somebody came up with some rule that if it's under a minute, it's not infringement. That's wrong. There's no such rule. But again, if a news broadcaster takes a small portion and they're commenting on the portion of that work, that is likely to weigh in favor of fair use, right? And then the final, I would say, factor that is considered across all jurisdictions is whether the work that is used supersedes the original work. So if the purpose that you are using the copied work, right, the second use, if it supersedes or overrides the purpose of the original work. So now that you're using this work, does the original creator lose a market because you already used the work, right? So is that work identical, or have you transformed it in a way that is different, that does not replace the use that the original owner intended? So and there's no one factor that's dispositive, and by dispositive I mean there's no one factor. If you have this one, then you win or you lose. Again, the courts will weigh them. So you want someone who is knowledgeable in case law or with the different various cases that have come up in the news to help you weigh those things on whether or not you should potentially rely on fair use and not get a license. As I said at the beginning of the podcast, I tend to, have my clients err on the side of caution unless it appears to be just obvious. Like I said, a page, a chapter out of a 50-page chapter book or something like that, for educational purposes. I would say err on the side of caution and get a license.
I definitely would recommend that as well. And even before that, what I would recommend is once the particular person on your team who is in charge learns this, as she was speaking about policy, creating training so you can teach your team, because no one is always able to review all of the content, especially digital, before it goes live. So in order to keep yourself out of a tough predicament, make sure that everyone within the circle who is producing and distributing content on all of your social channels, on your digital, on your stream, in your apps, that they know what rules apply. And so I know we went around it, and I even want to talk a little bit about the Ed Sheeran copyright case, but we'll do that later. I do want you to I want you to talk about hashtag ad and what that means for talent influencers. And for us, our influencers are our own air talent. And I know particularly I've sat through trainings that teach you what is the quid pro quo, what is all of this, especially because that is also a case that goes on for terrestrial. But when you are doing any type of promotion on social media and you're getting in a paid advertisement, you have to make sure that that is disclosed to the audience. And I know Kim Kardashian was recently sued, and she lost that lawsuit because of that. And there's been a lot going on. So tell us a little bit more about that.
Okay, so hashtag ad means nothing.
What?
We see it a lot, but it means nothing. So let me back up a little bit before we get into that. So if you are an influencer or you endorse a product or service, you have to, so the FTC requires that all advertising be honest and truthful. So it's not unfair or deceptive. The purpose of most advertising laws, and really data privacy too, is to protect the consumer, right? So if there's an influencer or someone who's endorsing your product, they have to disclose that they are receiving something. It doesn't necessarily have to be money, but if they got a free product or a discount or a free night at a hotel, whatever, they have to disclose that that endorsement is made in connection with some financial, well, not necessarily financial, but some relationship that they have with the product owner. Okay. Now, you do have to indicate that there is some affiliation, that there's some relationship. You can use hashtag ad, but if the only language that is on the ad is buried in a bunch of hashtags, that will not be sufficient. And if the FTC catches you, you could be fined, because they do not consider that a conspicuous disclosure. Disclosures need to be clear and conspicuous. So an example of a better disclosure would be to put it in, and even they say just in the profile is not enough. It needs to be associated with that actual post. If it's embedded, so sometimes if your caption is too long, it'll put a more, I think it says more, or you have to click something to see the rest of it. Well, if your disclosure is in that thing where you have to click to get more information, that's insufficient as well. So the consumer needs to see it up, bam, in their face. Otherwise, it is insufficient. So to your earlier question, hashtag ad buried in a bunch of other hashtags is insufficient.
This is wonderful news to hear. I was taught that we always make sure that we put the hashtag ad, but then even beyond that, I know in recent years capabilities have changed when we are posting to social media, and so they do flag when they start to see that maybe this is a partnership. So they will ask you when you're posting, is this a brand partnership? So that is your duty to make sure that when you are posting, that you make sure that you place it that is ad. I know YouTube does it as well. They put an icon in the left corner, but that you put the affiliation of whoever it is when you're posting, because now we have just learned, guys, that hashtag ad is not enough. And so we, as she was just mentioning, make sure that it's front and center. And do you have anything else to add about that topic?
No, that's really it. You just want to, like I said, you just want it to be clear and conspicuous. I'm guessing that the reason that they put are you saying that they put like a little watermark on the video or something?
On YouTube, there's just a little icon that comes up to let you know. It's like a little button in the left corner that says this is a paid promotion. Okay,
and that's why, because if someone has to go down into the comments, into that caption, you're only allowed so many characters. They want to make sure that it is clear. That's why.
Definitely.
That's there. Mm-hmm.
Now I'm just going to take it now to, let's talk about data compliance. Okay. This is one that could be in.
How much time we got?
I know, right? And I don't want us to get into the weeds of it. All I really want us to talk about today is the personally identifiable information, knowing how we collect it, why we have a privacy policy, and then just how to keep yourself compliant with that data. And I think that'll keep us from our heads, blowing up.
Okay. Okay. So, unfortunately, the U.S. does not have a comprehensive federal law that addresses data privacy. It is a patchwork of regulations. But generally, the laws, like I said earlier, everyone's familiar with GDPR as well. So that is Europe's data privacy.
And what does it stand for?
What the GDPR is Europe's data privacy regulation that governs how people can collect and use data submitted by a consumer, or not submitted, but of a consumer. So although Europe has a law that governs all of Europe, U.S. doesn't have a federal, one that governs all of the U.S. However, there are some federal laws that do protect data, but it does not provide a framework like the GDPR does, right? So for instance, the FTC Act, they do enforce whether or not so for instance, Facebook was fined because they told users that they were going to use data one way, and they either didn't do it that way or they used it a separate way. And so the FTC Act protects that, but that's not really specific to how personal data can be used or disclosed. You follow me? Does that make
definitely
sense?
do.
And so that's the distinction. Now, there are state laws that do specifically specify how an entity can collect, use, disclose data.
So give us some examples, typically. So this was a huge lesson for me as well. When we were learning about the privacy policy, it's the use of the data. So for example, for our broadcasters, if you are collecting your audience's name, their address, their phone number for the newsletter, and tell me if I'm correct, Dayna, but in your terms, this is where you are telling your audience how you plan to use that data. So if you're signing up for the newsletter, you're telling them you are signing up to receive this information or maybe more advertising. If you turn around and sell their data, that's an infraction, correct?
That's correct.
You take me further because you know how to explain it.
Right. So that is correct. So a point of clarification. So typically websites have a privacy policy and a terms of use policy. Those terms of use contract or terms of service, those are two separate policies. Okay. So the privacy policy advises the consumer about how the website or the website owner is collecting their information, and how they will use it. And then the example that you just gave, that they have to be in compliance with their own policy on how they do it. If they don't, there are hefty fines. Just ask Google. Google had a privacy policy up for about 8 months. It was inaccurate, and they were, the FTC fined them hundreds of millions of dollars, because the privacy policy wasn't how they were maintaining it was not aligned with how they were actually handling the data. So that's the privacy policy. The privacy policy, again, just advises the consumer, we are collecting this information from you. This is how we intend to use it. And you have the option to opt out or have your information scrubbed from our system, or tell us to leave you alone. Okay? That is what the privacy policy does. The terms of use is different in that the terms of use is just that. It provides the website user, again, a contract with, this is how you are permitted to use our website. So for instance, let's say you have user-generated content capabilities. or capabilities to allow users to upload information. That's called user-generated content. There may be some restrictions in that terms of use about what they can upload, what they can't upload. So you gave an example of YouTube earlier. Also common in those terms of use policies are other ways that you can use or cannot use, restrictions on how you might be able to use that business's intellectual property. Can you take images off of the website? Can you take their logo off of the website? Whatever, how you might be able to use it. That is what the terms of use dictate. Or convey to the website user. So they're two distinguishable contracts that are on the website. I know you wanted to talk about data privacy right now, so I don't know. I think I kind of went off on a tangent, so I don't know if I answered your question.
It is easy to do because it is so involved. And while you were speaking, I said, you know what? Let's not go too in depth. But what I want to do is I want to talk about the data privacy and why everyone pretty much needs it, because you're not always just getting the user-generated data from someone giving you their information. If you have any type of analytics on your websites, just your Google analytics, anything that is tracking page views and how people are engaging, maneuvering through your site, that is another form of data collection that you have to alert your users to. Dayna, go for it.
Okay, so let's just back. So earlier you talked about some different types of PII, or personal information, personally identifiable information. So personally identifiable information, just real quick, is everything from your name, your address, your phone number. It can also, so the GDPR does consider your IP address as far as your we're going to say PII because it's just easier. So your IP address, your geo, so our phones, our geolocation, so our phones pick up where we are located. The reason that is PII is because it identifies a particular person, me, at a particular time. So it definitely indicates that that's Dayna and not my boyfriend, who may have been using my phone but is somewhere else, because he was at somewhere else during that time. So that can't identify that individual person. Does that make sense?
Correct.
Okay. Your driver's license. So every time you may collect that information. All businesses have somebody's, whether it's a consumer or their employees, personally identifiable information. When you collect this information, the law has said that you have to be a good steward of other people's information, right? And that you have to use that information responsibly and ethically, which is why you have to disclose to them how you're using it. You can't just say, oh, we're going to use this for internal information. So what a lot of privacy policies say is we use this to make our website better. When you're actually selling it to a third party to monetize the data, you just can't do that. I think you mentioned at events. So at events, you may have a sign-up list. That information is PII that needs to be included in not necessarily in your privacy policy, because it wasn't the consumer did not engage with your websites, and it's obvious that they're giving you this information because they signed up for it. But the other thing that's important about a website privacy policy is that sometimes you're collecting information from that consumer, that website user, that they don't know that you're collecting. And so that's the difference. So I know that if I go sign up for your newsletter, that you have my email and maybe my first and last name, but I may not recognize that you are tracking my IP address in the background, right? And that, or my geolocation, so that you can, let's talk about IP address. So now you're sending me other advertisements based on that IP address that you're retargeting, and now you're retargeting and marketing to me. You have to basically inform your consumer that you're doing that, and they need to know, so that if they decide that they do not want that type of marketing targeted to them, that they can opt out of it. Essentially, that's what the law is. Well, that's the purpose of the law. To
Yes.
give consumers some authority over how their data is used.
Yeah, and we're even seeing, I believe it was Google Chrome that is going to do away with the technology that is going to allow you to track. And then we also know that Apple and their operating system now, it is not automatically turned on for them to be able to track it. You actually have to give permission. But you hit on a huge point that opened my eyes one time, is when you are talking about events, or if you're using some other type of software widget or technology that is taking in that user-generated content. For example, something like Eventbrite. Give us some examples of when you are using, because you don't necessarily think about it, of when you are working with these third-party vendors and you're saying, well, the data's coming to me. It is coming to your organization, but first it's going through another company or software, and they actually now have access to it. So give us some examples of where that applies.
Okay, so that's a really good point. So you're not only responsible for the information that you obtain yourself as a first party. So for instance, let's say I have a website. I do have a website, right? On my website, I have a contact form. And then Ashley comes to my website and she puts her information in her contact form. So clearly I obtained that information from her, right? So I'm responsible for what I do with that information. But we also have plugins or some type of APIs or whatever that are, okay, I'm probably getting too technical, but we have other widgets or technology connected to these websites that we do not control, right? So they're like you said, third-party vendors. Well, to the extent that you have incorporated that into your website, you have essentially given somebody else access to that person's data. You're responsible for that. We have to be good stewards of our consumers' information. Okay, so you're responsible for that. So typically when you are considering these vendors, you want to find out if they're compliant. Are they aware of the laws, right? So that you can ensure that they are using it in compliance, because why? You have given them access to your client's data. A lot of times you can protect yourself by ensuring that the contracts and GDPR actually has requirements that have to go into certain contracts to ensure that when you're working with third-party vendors. So again, in short, you want to make sure that the vendors are aware of the compliance issues that they are, and really that those contracts kind of indemnify you. And what that means is offers you some protection or insurance in case something happens on their end and the data is mishandled, or even if it's unintentional, they could be subject to a data breach, but now your data is over there sitting on their servers or on their systems. But the only reason that they have access to that data was because they got it through your website, because you allowed them access. So essentially, that is the problem that you run into, or I shouldn't say problem. One of the considerations that you should consider when you are looking at a third-party application or vendor to collect data on your behalf.
So we have mentioned first-party and third-party data a lot. Please tell the audience what those terms mean.
Okay, sure. So first-party data is, again, I'm the first part. It's data that I collected on my own. So again, my website, I collected the information from you via my contact form. And let's be careful with that, because you may have a third-party app that is the contact form. So although you collected it, it was really through kind of an intermediary, right? So you got to be careful.
This is when your web developer comes into play, and she's going to talk a little bit about it, but this is where data mapping comes into play, and we'll talk about it.
Maybe we should have talked about that first, but yeah, we can get back to it. So first party. So a better example probably of first party data would have been the events example that you gave. So I'm at an event and I say, can you please fill out this survey or fill out this form? And then we take that back. Old school, it's on paper. I guess we're gonna put it in a database or somewhere. Or let's get with current times. We give them a tablet. Can you please fill out this tablet? But you know what? Let's take the first example. Let's talk about paper. So paper is less secure, right? You put all those papers in a box, and that box gets lost when you're shipping it from Atlanta to wherever, or you send it to now another vendor to scan it in. That data has now had 2 or 3 touch points, right? You are responsible from where that data, what they call it in the law enforcement chain of custody, what they call it? Is that what
I think that's it? Yes.
Yeah. So you are responsible for the chain of custody of that data. Again, we have to be good stewards of the data. In order to do that, to your point about data mapping, so typically when we are employing these technologies and how we are managing our clients' data, in order for us to be good stewards of our clients' data, we want to know every data touch point. So in order for us to do that, I have my clients create, if they haven't already, if their developer didn't do that, data maps. Where is the data? We inventory the data. What kind of data are we taking in? What are we consuming, right? And what are those data touch points? So that's the map, or like a flow, right? A data flow, so that we know where those touch points are. Why do we need to know where those touch points are? Because if a consumer wants to opt out, I have to remove that data from those touch points. So we have to be good. In order to be good stewards, we have to be able to know where to find that data to handle data requests. So I'm thinking in media, you're going to, well, that's really government, but like government, there's FOIA requests, right? So in order for them to give, so the media is going to contact the government for Freedom of Information Act. For those who don't know what FOIA is, in order to get that information, they have to know where to go to find the information, right? So again, those data touch points.
And before you go on, Dayna, I just want to give a real world example for that. And you touched on it a little bit earlier. So for instance, if you have an event and there's a form fill on your website, and if someone were to ask you, well, where does that information live? You go, oh, it's on our station website. But if you go back and you talk to your developer, you will find out that maybe the form that they used was not actually a part of your website. And this is a third-party vendor, right, a totally different company, and that technology has been added to your website. So even if I do go on the back end of the website, the information is actually living in that company's software.
Exactly. And so it's on their server, and you're accessing their information from their server. You don't even have it, which is problematic, right? So that, again, that's the example that I gave earlier, because like you said, that contact form may not be something that you have control over. But I went off on a tangent again. I'm sorry. So that's first party data that I collected, that I have control over. It's on my server, or within my little box of papers of your information, which we want to get out of people doing that. We want to go digital.
First party data is our recommendation these days with the way technology is going.
Absolutely.
So you want to make sure that you are compiling as much of your own data, because sooner or later, with what we're learning about the third party data and what they're doing, because a lot of audiences do not want to be sent all the retargeted messages from places that they know that they did not give permission to. That is where all of these regulations are coming from. Just for it, and it benefits your user experience. So I'll stop on my tangent and let you get back on yours.
Okay. So yeah, and I'm gonna say this one more thing, and then we're gonna go to third party data. So the other thing is so back to my earlier point about making sure that your vendor has ethical in the handling of their data. So let's say that you use a third party, like you said, that is collecting that information. Well, if you didn't consult with their privacy policy and they're sharing that data or they're selling it to another vendor, you're on the hook. You're on the hook for that, because the consumer thinks that you're collecting that data. You haven't told them that you have someone else that is collecting that data on their behalf, and that they are subject to their data policy. You have to put that in your privacy policy to let them know. And that I have a case right now in arbitration. You want to make sure that, I'm going on another tangent.
You go for it.
Third party data. But I know I'm such a nerd.
You have to be in this space.
But it's getting good. It's getting good to me. So
let it do
it. Right. So you want to make sure that the client, the consumer, at those points where they are, especially if they're voluntarily giving data, that they're consenting to certain types of use of that data. You want to make sure that there's an actual consent. So there's two types of consents. There's what's called a browse wrap, and then there's what's called a click wrap. So we went through this with your form, and I said, make sure they check that box.
Sure did.
Because you do not want to later come up, some type of dispute happens, and the person said, well, I didn't see that policy. Well, you check that box. So if you didn't read it, like Tabitha Brown said, that's your business. But you need to read that policy, because that may be the only thing that so the word is indemnification, but that may be the only thing that frees you, alleviates you from some liability for mishandling of that data. Okay, so all of that to say, first party data is data that I collected on my own, right?
You own it.
Yes. Well, I wouldn't say that I own it, but I would say that I collect it.
Okay.
Because my position is that we own our own data.
Okay.
So that's my position, but I'm nobody.
I'm going to take the attorney's recommendation.
So third-party data, there's also second-party data, but we just won't. Second-party data is really just another company who. So if you're collecting data and I'm collecting data and we trade data, right? You're the second party and I'm getting data from you directly. Third party is another, so it might be, and it really can be on a case-by-case basis, because, for instance, Facebook, they aggregate data on themselves, but they may be getting data from another party. So it really is kind of a case-by-case, but essentially second-party data is I contracted with another or entered into some type of partnership with another company, and I just took the data from them, right? They gave me a list. A third-party data may be, again, someone else down that chain of custody who, for instance, you may have purchased a mail list. Well, that could be second-party data too, but it's essentially data that you did not get directly from someone. So in the second-party example, I got data directly from you, but the data that your first-party data, right? But if you got data from someone else and now you're sending that data to me, that's third-party data. So I think the easiest way to just think about it as the chain of title of the data. So not to get so bogged down, because I would say the importance of it is really just, like you said, you really want to get the most of the data yourself as first party in order to have some more assurance about the integrity of the data. But the further down the chain of title, it gets murky, right? So that's really what I would say, so that we don't get bogged down and scare, bore people with or confuse people about, the data privacy nuances.
And what I want to do is give a real world application to this third party.
Okay.
So majority of broadcasters, you have some type of programmatic ad buying that's a part of your capabilities. You might be doing site retargeting, contextual retargeting. And what that would allow you to do is, say, for instance, if you're a sports broadcaster and there's radio programming or a sponsor that has, or advertiser rather, that would like to also target additional more sports enthusiasts beyond your own audience. So what we traditionally might do is like a boosted post on social media. That she was mentioning, you have an aggregated pool of people in that third party data that when they are looking at their engagement on the internet, they're saying this person frequents a lot of sports news websites, or they watch a lot of sports videos. So they automatically put you into that group that says these are sports enthusiasts. you do not have their identifiable information, but that third party does. So when you create that ad or that lookalike audience that has all the characteristics that you're looking to reach, you're now using data that is beyond, as she mentioned, the data that you have collected yourself. So that is an example of third party data, and you tend to see that a lot with programmatic ad buys.
Proud mama moment again.
Say it again for me.
I said proud mama moment again.
It only takes a couple times and then it clicks. No, but what I do want you to do now is what I know I started over there and I went all the way over here. But for anyone that does not understand anything of what we just spoke about when it talks about first party or third party data, but if you own a website and you have analytics on that website and you are looking at how people are engaging and interacting on the back end of your website, explain to people why that is considered data and why the audience needs to be alerted that you are tracking them.
Okay. So all data is, and I think this is one of the first conversations that we had, is it's just information, right? So we all know that Big Brother is out here and he's watching us, or she. And we all recognize that we're leaving digital footprints, right? But we should have some level of privacy, right? So we can, what I just said with Tabitha Brown said, so we can maintain our business, right? And so, but in order for innovation to blossom and flourish, typically it requires a little bit of encroachment upon somebody else's rights, right? So the data privacy laws are really about balancing innovation with our rights over our business. As Tabitha Brown would say.
I think that's a great
explanation. My business. I want to keep it my business, and I may not want you tracking me about what me and my girlfriend was talking about in the group chat the other night, right? So it's really, so I'm being funny, but seriously, it's about us having a little bit of control over our information, and these laws are in place to kind of balance that, so that we just have not, so that the consumer does not have to give up all privacy rights.
Thank you for that explanation. And where I want to take us to next is could be complex, but we're going to keep it very top level today. Is that what most people might not notice, and they might not know unless they receive a fine. Let's talk about accessibility. And let's talk about the user experience and what we have to do in order to remain compliant.
Okay. So just like we have to make accommodations in the physical realm, we have to make accommodations for people with disabilities. Well, the same thing applies on the internet. People with disabilities are entitled to be able to use the internet like everyone else. Failure to have an accessible website is discriminatory and could result in very high fines. Some more fines.
That might be the theme of today.
Promise we're not trying to scare you.
No, we're trying to help you avoid fines.
Right. Fines and attorney's fees. There's I have a client that received a cease and desist, not a cease and desist, a demand for some god-awful amount of money because they alleged that the website was not ADA compliant. So there's these law firms in California, one in particular, and I believe, I won't say any names on here, but I believe that is really bordering extortion and blackmail. Because what they do is they go to, I don't know how they come up with the websites, but they just kind of scrape these websites to see if there's anything. So if your image does not have a caption that the blind person or can't figure out what that image is, they send you some demand letter for $1 billion. but it's really just kind of taking advantage, especially of small businesses, in the name of ADA compliance. I'm a firm believer that disabled should have access. But like I said, I just really think that the tactics are bordering extortion and blackmail. Because typically, you know, if they're demanding $500,000, you know, it's cheaper to settle. I mean, even if you go to court and you fight it, you're probably gonna, even to get a complaint or to answer a complaint, you're looking at $5,000 to $10,000. So that what ends up happening is they negotiate with some other law firms, and then they get $5,000 here and there, or they may, for a larger corporation, they may get $50,000 just to go away instead of litigating it. And that's essentially what it boils down to. But that's a long way of saying, make sure that your websites are ADA compliant. In order to do that, there are plugins that you can use. There are plugins that you can use on your website to make it ADA compliant so that it's accessible to people with disabilities.
And one of the tactics that is one of the most general is what Dayna just mentioned, is when you are doing your post and publishing on your website, when you're putting up anything regarding content, as far as like especially your videos and the imagery, making sure that you're writing the detailed caption of what is actually being seen, because with those plugins, it then reads the caption to the reader. We can go down an entire rabbit hole of the different tactics that you can use, but just like Dayna just mentioned, have your developer to go through and just Google the different capabilities in order to make your website ADA compliant. And then what I also recommend is we also had to go through training for that. So this is another policy and training mechanism to put in place. And what I want to do, Dayna, before we come to an end, is I just want to give you the opportunity to add anything at a very, very top level that you think that we might have missed. And we know that we could probably have a year-long series on this, but we just want to, get their feet wet. Put a bug in their ear about, these are the type of things that I need to be considering in my operation.
Mm-hmm. So get a lawyer. I would say, I do recognize that a lot of people don't have the budget, right? So just get a director, take a class, and document, some policies, guidelines that you can follow. The FTC has a tremendous amount of guidelines on the website, and if I'm being completely honest, I use those as a baseline to advise my clients when we're developing procedures to maintain compliance. So that's a great starting point for you and a free resource. But overall, I would say is again, get someone who is knowledgeable in the field. If you can afford a lawyer, you want a lawyer, but you want to ensure that you're protecting your content, that you are licensing other people, you're fairly using, so fair use, or licensing other people's content. You want releases. We didn't really talk about that before, but a lot of times, like if you want to use an individual's likeness or image, you want a release for that. So we talked about stock photos, making sure that those stock photos that the appropriate release language is in there too. What else? Contracts are in place. Proper contracts are in place, because that could affect your ownership or non-ownership of content that you thought that you were using on a website. Let's see. Independent contractor agreements that clearly outline the ownership rights of that content. The last thing you want to do is think that you own this photograph and they're still claiming ownership of it. What else?
That's a huge point. You want to make sure that, and I'm working with someone right now, you want to make sure that you have read from the top to the bottom every part of that contract, especially when it comes to the creative of that, because you can have the rights, as she mentioned before, you can have the right to use it, but that doesn't mean that they don't still have the right to use it, or
Right
that
to
they
use it.
can own it and use it for however their use is, which might be contradictory to whatever your mission and objectives are.
That is huge. That is, and you know, that's I would say a large majority of what the where the disputes lie, right? In ownership. What else? Again, I could go on for hours, but yeah, I would just say, you know, have some proper guidelines. Again, if you can't afford counsel, then have some preliminary discussions so that you at least know which direction to go in. And then you can consult with them on a case-by-case basis. But it's very difficult if your expertise is marketing. It's going to be very difficult for you to be in the weeds on the legal aspect of it. So it just makes sense to do it right on the front end before you get hit with a $175 million fine from FTC. Hey, I'm just saying. Like I said, Google had it up there for 8 months, and it was purely accident. You know, it appeared to be accidental. But again, the law is really about protecting the consumer to ensure that people are not, you know, misusing their information or misleading them. Because that's all the consumer has is the word of the advertiser, you know, to rely on what's published. And so that's really it. Like I said, just protecting your content and ensuring that you're getting the proper releases and permission to use someone else's.
That is the gist of it. I just want to thank you, Dayna, for coming on the show. I hope for everyone else, it's always enlightening when I talk to you, and I always learn something new, and I definitely did, you know, even today. But what I want to do is I want to go ahead and close us out. You guys can visit Dayna's profile on the general landing page for the podcast. You can then find her information on LinkedIn, and then we'll also have different ways for you to be able to connect with her. Thanks for listening to As a Result. Find new episodes on the Dimensions Media YouTube channel and all your favorite podcast platforms. Subscribe to our YouTube channel and turn on notifications. For industry updates, sign up for the As a Result newsletter at dimensionsmedia.com. Thanks for listening.